On behalf of the University of Baltimore, I would like to welcome you. Thank you so much for being here today.
Thank you.
If you could please briefly tell me a little bit about yourself, where you're from, introduce yourself.
I'm from Catholic University in Brazil, Pontifícia Universidade Católica of Minas Gerais. It's a state in the southwestern Brazil, you know. And there I used to teach administrative law and also environmental law. And I have been there for almost 20 years, I think. And what else could I say? I'm a lawyer, and I have been working also with some NGOs in Brazil concerned to urban space and things like that.
Okay. Well, today you gave us a very interesting lecture on law and feminism. If you could please just give us your main points, what you want us to take away from your lecture today.
Okay. Basically, I came to say that we have a sort of a symbolic force of law, which applies to not only to gender policies, but almost all public policies. And this symbolic perspective of law is based on the fact that some laws are produced to not produce any effect, you know. And I use the ideas of a Brazilian philosopher, constitutionalist, which is Marcelo Neves. He has a book about it, which calls A Força Simbólica dos Direitos. In fact, it calls a constitucionalização simbólica. In this book, he discussed this symbolic perspective, which is not a linguistic perspective. It is also a legal, political perspective. He presents three categories or types of symbolic laws. One is that one which is built, you know, produced to reinforce social value. But we also have laws that are produced to postpone a social conflict. And also laws we are built to how can I say, to reinforce the political governmental power. Based on this, I'm basically saying that we need to consider that the gender public policies, you know, haven't been so succeed, in the sense that we still have a gap between those two worlds. So the right of being a woman in this country, you know, it's something, or in any other democratic countries, it is also an issue for everybody. So, well, or for public administration. Well, to shift this, I consider that we have to re-signify the way that we have been treating the administrative law and the separation between the governmental function and the administrative function and executive power. I also consider that we have to bring some experience on participatory movements that we have in that has been ground in South America, and especially in Bolivia and Ecuador. Then we need to understand this a little bit better, and we need to redefine our idea of transparency. You understand? So I would say that those are the main perspectives of my speech today.
Okay, what would you like Americans or American law students and lawyers to learn from your lecture today?
Well, to be sincere, what I would say is that we need to start to rethink the way that we have been dealing with law and all those theories that support law. Maybe we should to try to re-signify some of them, as this Montesquieu's theory, for instance, and also the idea that we have of the rule of law and the state power. Somehow we have been controlled, in a huge sense, and this control, in a certain way, they are necessary, because we live in a society and maybe we are not be able to organize it by ourselves in a proper way. But the truth is, not everybody is under control, and also not everybody belongs to the society that the rule of law grounded. So, as not only in a feminist perspective, but also in humanist perspective, I think if you are studying law, you should consider the reality that is surrounding you, and you should try to think about it, in a more positive and constructive way, not only replying things because you read in a book or because you think that must be like this. You understand?
Yeah.
You need to be a little bit divergent sometimes.
Okay, well, thank you. Do you have any concluding remarks, any final thoughts for us here?
Well, you mean concerning the speech?
Yes, yes.
Okay, concerning.
Or anything, if you have anything you want to say before you.
Well, here I think it's a little bit difficult to understand what the symbolic force means and what's necessary to promote a sort of shift, a sort of turn or screw in this perspective. And what I have to register here is that maybe our legislative power, is producing law just to regulate something, not really to make something happen, not really to reinforce any sort of rights. And if this premise is right, we have to be aware about it, and then we have to try to understand what is blocking this power, in an administrative perspective. Because the truth is, it's not the judiciary which is responsible to apply law every day. It is the administrative power which does this every day. So if we put all of our coins on judiciary as a means to solve conflicts, we are considering on the other way around that the administrative power has failed, if you understand what I mean. So I think in spite of supporting the idea that the symbolic force of law is grounded on legislative power, I think the solution for this is the way that we have been treating, the executive function in a democratic rule of law. So we need to reframe this. We need to be more concerned about the planning, the function of planning, and as lawyers, as professors, or as an academy that is working, how could I say this? As an academy that is committed with the idea of effectiveness of any rights. Okay.
Okay, thank you so much for being here today. We really appreciate it.
Thank you.